the Supreme Court ruling on the 1849 abortion law was just released this morning.
Yeah, just dropped this morning. I guess just a quick recap for your listeners. This is a case that has been working its way through the court system for several years now. I was actually originally on the case. It was really weird how this case came about. Recall after Dobbs, there was a lot of litigation nationwide because the issue was returned to the states. And so this is actually a case involving the title of the case is Call versus Urmanski, and that sometimes the titles you have to kind of pick apart. Well, Call, AG Call. So we have the Attorney General who actually sued Joel Urmanski. Joel Urmanski is the district attorney of Sheboygan County. So Call actually sued Urmanski, and then the DAs in Ozark and Madison, or Dane County, and Chisholm, at the time DA of Milwaukee County. And he did that because those three counties were the home of the 3 or 4 major abortion providers in the state. And so the AG very proactively sued those 3 DAs, which I think, right, I mean, that's a whole nother topic as to whether or not that's appropriate, or, is this the type of AG Wisconsin wants, that's suing another public official in their official capacities to, promote the expansion of abortion? Let's just set that aside. But that's how the case came about. There was a decision out of Dane County that focused on whether or not 940.04, that's the statute that's at play here, that's a statute that does go back to 1849, that essentially completely prohibits abortion, with a narrow exception for the life of the mother. And that case was litigated in Dane County originally, and the judge in that case actually found, well, 940.04 doesn't really apply to abortion. It just applies to infanticide, right? So if you assaulting a pregnant woman, that results in the loss of the child, right? That's what 940.04 really did. She relied on a case of State versus Black, and that was her ruling. Urmanski obviously appealed. They bypassed the Court of Appeals, went straight to the Supreme Court. There was oral argument, I believe, last fall. I think you and I have talked about that oral argument. I encourage people to go and listen to that. So unlike the U.S. Supreme Court, our state Supreme Court, those are all recorded oral arguments by Wisconsin Eye, a great service they provide. Extremely aggressive questioning of the attorney for Urmanski, who I know, who I used to practice with. He's just a tremendous attorney. A tough argument to make, but one that I believe was consistent in that the legislature over the years has made various additions to the kind of abortion framework, but the 1849 law still stood, and that was a legislative decision. And so that was a tough argument to make, I think the right one. And he was just almost personally attacked by several of the justices. And again, Matt is a good friend of mine, so I'm obviously a little biased, but I think anybody objectively watching that would have been really turned off at how aggressively they were questioning him, because it was almost like they were basically, framing his arguments as absurd. And all he was doing was just objectively applying the law and basically making the argument that, look, if you disagree, right, go talk to your representatives, and the legislature needs to change its framework, but it's not the court's job to do that. And then that leads to early, and then we basically had nothing since the oral argument until today. And so this morning, the decision dropped. Interestingly, the court really did not adopt the circuit court's reasoning, again, relating to infanticide. What the court did here was kind of resurrect an argument that it kind of, I thought, lost its appeal, and that was implied repeal. And just a quick primer on that. So the argument goes along the following lines. You have a statute that the legislature passes, Statute A, right? And then you have a series, or it might be one statute that's later passed at a later date, or a series of statutes, B, C, and D. And implied repeal basically suggests that, well, the legislature may not have repealed Statute A, but because of B, C, D, E, F, just go down the line, they're impliedly repealing Statute A. Well, the A in this hypothetical is the 94004, the 1849 law. And the court basically said, look, we've had all sorts of other statutes that the legislature has passed relating to abortion, the 20-week ban, a ban on partial birth abortion, the radius, right, that the practitioner has to practice within 30 miles. There's all sorts of other additions that the legislature has added. And so the court basically embraced this implied repeal concept. I disagree with the decision. I think, and we're still kind of reading through it. Admittedly, it's over a 70-page decision. I haven't read through the whole thing. So it looks like there's some pretty strongly worded dissents. We're going to have more analysis through the IRG court watch in the next day or so. But it looks like some very strongly worded dissents. And the problem is, like many of these decisions, I believe there's a Karofsky concurrence that reads, it's pure policy. It shouldn't be surprised. You shouldn't be surprised by this. These justices ran on their values. This is something that we at IRG have been talking about for 2 years now, that is a very dangerous path we're on, that you have justices that are running, or candidates for justice that are running on their values, as opposed to their judicial interpretation, views, whether it's originalism or textualism, right? They're running on their values. That is a very dangerous proposition. And, a lot of the political folks will say, well, we can't really talk about that. We need to talk about, law and order. Well, everybody's for law and order, right? The left has gotten very good at talking about those issues. Instead, now they talk about their values. We need to make clear, and this is Exhibit A, on what happens when you have candidates for higher office that get elected and rule based on their values. The Karofsky concurrence reads just like a pure policy white paper on the merits of abortion. That is very problematic. From a legal standpoint, the majority decision is problematic because the standard for implied repeal is intentionally very high, right? Because there's this judicial interpretation principle that when the legislature passes a law, they are aware of all the other laws in the books. Now, does that mean a legislator an individual legislator is reading every single statute on the books before they propose a bill? Of course not. But as a matter of interpretation, we kind of assume that the legislature knows what they're doing. And so when they pass, in this case, subsequent abortion laws, we should be presuming that they knew about this 1849 law and still proceeded to enact other statutes. Now, is there a better framework? Maybe. And that's something that we could debate. But at the end of the day, the legal question is, could somebody still operate in Wisconsin under this abortion framework? The answer is yes. Justice Hagedorn, during oral argument, I think did a very good job kind of laying out that line of questions. That, look, you can have a policy debate, but that's not what the court should do. And they should respect the legislative prerogative. And so, I guess my final point here is we're on a very dangerous path. We're electing justices that now write decisions based on their values. And we're now watering down, I think, a key construct where the court going forward could apply this implied repeal to any number of other scenarios to basically suggest, well, the legislature has spoken on this issue subsequent to an earlier enactment, and it relates to the same subject, and therefore they're impliedly repealing the earlier enactment, right? We've talked about the watering down of rational basis review. I think these are all constructs that are being implemented in majority decisions to try to weaken the prerogative of the legislature, to weaken kind of the respect the court shows the legislature as a co-equal branch of government. And so this is just one more exhibit. We're continuing to work through all the other decisions that are being released, because just like the U.S. Supreme Court, this is the end of term for the state Supreme Court, and I guess more to come from IRG on the other cases. But this is absolutely a major decision that was just released this morning.
Oh. So, I mean, I guess, is there any recourse? I mean, can it be elevated? It won't be elevated to the United States Supreme Court.
No, this is so. I mean, this is where and you and I have talked about this in the past. I think people it almost we get a little lazy where we think, well, the state Supreme Court doesn't matter as much because we have this wonderful conservative U.S. Supreme Court that I think is doing a great job. And even if there are decisions that, from a policy standpoint, we don't like, we have 6 justices that I think objectively apply the law. And again, I disagree with some of the decisions. I don't think they get it right every time, but I think they are actually trying to apply an originalist, textualist interpretation to decisions. That being said, there has to be a federal issue, right? And here, this is an interpretation or an application of a principle. Implied repeal is kind of the construct that's being applied to Wisconsin law from 1849 onward. Maybe there's smarter people out there that think there's a federal question here. I don't see it, and so no, I think this is the final decision on this issue. As far as most immediately, what happens is because the 940.04 sub 1, which is kind of the statute at issue, because that's now been quote unquote impliedly repealed by the legislature, despite them not doing anything. But the court is essentially finding that. We go back to kind of the pre-Dobbs framework, which is a 20-week abortion ban. So that's I think essentially from a very practical standpoint where we are. We're going back to a framework where abortion is legal up to 20 weeks. And as to whether or not there's more to come, I would remind listeners that there's a case that's kind of just sitting there involving Planned Parenthood that is essentially a direct constitutional challenge that essentially asks the court to find a constitutional right to abortion. And so this is where I hate to get too cynical, but one has to wonder, this at the end of the day is the current case current decision is limited in that all it's doing is repealing the 1849 law, leaving in place the 20-week abortion ban. But in the background is lurking this Planned Parenthood case that if the court takes it up, and I have to check on the procedural posture, but it's just been sitting for I think over a year. But if the court takes that up, and there's oral argument on that case, and it could be an opportunity for this court to find a very robust constitutional right to abortion. Where that line would be as far as the number of weeks, I guess we'll see. But again, this is a problem. We're left with essentially a majority on this court that is essentially going to make policy on one of the most critical cultural issues of our time in the state. And ironically, right, we're kind of mirroring what's happened at the national level, but we're going in the other direction, right? We had a Supreme Court that basically said in Roe versus Wade, we short-circuited the process, that the people of this country should have, through their elected representatives, made the decision as to kind of what each respective state, how they would deal with that. I personally, right, as a pro-life individual, have a view, but that's an important cultural decision that the people's representatives should have a voice in, and Roe versus Wade cut that off. So Dobbs just simply returned that issue to the states. We're going the opposite way. We've had a statutory framework in place that the legislature has enacted, the duly represented individuals of this state, and now we have, just like we did in 1973, we have a Supreme Court that's essentially saying, you know what, elected representatives, the people, you've spoken, but we're going to kind of unwind all this. We're going to impliedly repeal a statute from 1849 that was amended in 1953. And with this Planned Parenthood case, we'll see where they go. They may take it a step further and say, you may have settled on 20 weeks. You may have had these other kind of regulatory frameworks in place, but we're going to take it a step further. We're going to find a robust constitutional right to abortion. And so, outside of even the abortion context, this is why individuals need to pay attention to the state Supreme Court. This is what we're going to do at IRG Court Watch, because whether it's abortion or Act 10, which is reminder to your listeners, that's sitting at District 2. That's going to be working its way up through the system, the appeal process. Right to work, prevailing wage. I still think school choice, despite the court kind of punting last term, I still think there's an appetite on the left to attack school choice. This is all at play. We have a Supreme Court election next spring again, and that's now we're on defense. That's going to be defending Rebecca Bradley's seat. So there's a lot of work to do with the courts, and Meg, I appreciate you allowing us to explain all this to your listeners, because it's so critical. It's a co-equal branch. Far too often, we kind of rank the branches. We all focus on governor, and then maybe kind of a step below that, we focus on the legislature, and far below that is the courts, and that needs to stop. These are co-equal branches, and we're seeing right now, if you have a very progressive viewpoint in one of the branches, it can essentially supersede a co-equal branch, and that's a problem. And so we're going to continue to focus on the courts, in addition to the legislature and the executive branch.